Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
May it please your lordship.
Yes.
My lord, by this petition, my lord, I am challenging the order at page 63, my lord. This is an ex parte order, my lord, whereby, my lord, a demand of service tax of rupees 11 lakhs in order has been confirmed, my lord. Lordship may kindly come to page 69, my lord.
Is there an alternative remedy, Mr. Dr. Mozika?
My lord,
What is that remedy?
Section 85 of the Finance Act.
So why do you come to the writ court?
My lord, no personal hearing opportunity was granted, lordship. Hearing opportunity was not granted, my lord. Here, lordship may kindly see page 69, my lord. Their order itself says, my lord, hearing notice was not served to us, my lord. My lord, page 69, para 6.0, my lord, personal hearing, my lord.
Where have you said in your writ petition that the email notice that was sent to you was not received by you? Where have you said that?
My lord. My lord, in para 9, my lord.
Paragraph 9.
So there was a lockdown, my lord. Our state
Paragraph
was,
9, let us see.
my lord, sorry, my lord.
Where have you said that you did not receive the email notice?
My lord, exactly the word email notice I have not said, my lord. But
Dismissed.
my
Thank you.
lord, my lord will just,
Avail of your remedies in the usual course.
lordship may then allow me to approach this some time for approaching the authorities.
Nothing.
Because my time, it is because
The writ petitioner does not dispute that there is a regular remedy by way of appeal, is it?
My lord.
my
By
lord,
way of appeal against the order in original dated September 3, 2020, passed by the Assistant Commissioner, CGST Shillong Division 1. Full stop. Paragraph. However, the writ petitioner refers to paragraph 6.0 of the relevant order to invoke the extraordinary jurisdiction under Article 226 of the Constitution. Full stop. The relevant paragraph refers to a notice having been issued by the department to the SSE, which was returned back with an endorsement, open court, always closed due to lockdown. Full stop, close quote. Paragraph. It is understandable that the SSE's office may not have opened during the lockdown. Full stop. However, it is evident from the same paragraph that the notice for personal hearing was sent through email, but the SSE was not represented on the designated date. Full stop. At paragraph 9 of the petition, the petitioner SSE has referred to paragraph 6 of the impugned order and the fact that due to the lockdown, the notice for hearing could not be served on any representative, full stop. However, comma, there is no reference to the email notice and, comma, it is evident, comma, that the petitioner may have received the email notice but opted not to attend the personal hearing. Paragraph. There is no doubt that the writ court has a discretion to entertain a petition challenging an order without requiring the petitioner to exhaust the regular remedy, full stop. However, such discretion may be exercised in extraordinary circumstances, namely VIZ, if the order appears ex facie to have been passed without jurisdiction, or the order is made without following the principles of natural justice, or the order is so manifestly bad that it shocks the conscience of the court, full stop. Paragraph. In the instant case, comma, there is no doubt that the initial notice went unserved, comma, but since the petitioner appears to have received the email notice and chose not to attend the personal hearing, comma, the petitioner cannot be heard to complain of the violation of the principles of natural justice, full stop. Accordingly, comma, in the tradition of the self-restraint that is exercised by the writ court, in not receiving a petition where there is an efficacious alternative remedy available to the petitioner, comma, WPC number 142 of 2023 is not entertained, full stop. Nothing in this order should prejudice either party, full stop. The petitioner is left open to approach the regular forum in accordance with law. There will be no orders to cause.
Only one small prayer, my lord.
Yes.
This order was 2020, my lord. And we received the certificate, we received the copy in 2022 only, my lord. At least 10 days time may be allowed. It is time bad. 10 days time may be allowed. Within 10 days, I will file my appeal there, my lord. Only 10 days, that much only.
The authority.
My lord.
We don't have the authority. You apply, explain why the delay was there. The appellate authority will act in accordance with law. Yes.
Obliging, Lordship.
Item number 2.
Delay?
Yes, Lordship.
How many
There
days?
is a delay of 1,801 days.
Very well. In view of the good.
My lord, appeal is not maintainable, my lord.
Not maintainable.
Not maintainable.
NIA.
It's no, my lord. It is conviction on the plea of guilt, my lord. On the plea of guilt, my lord. Conviction on the plea of guilt. Appeal is not maintainable. Section 370 of CRPC, my lord.
If there was admission of guilt,
It is admission of guilt, my lord.
deal with it.
Yes, Lordship. Means, see that appeal is maintainable, Lordship. Firstly, under 302 IPC, the punishment is either of life imprisonment or death. Here in the instant case, Lordship, the punishment awarded is 15 years.
Read 375. Read 375. Show us that it does not apply when we entertain the appeal.
In that case, Lordship, the preliminary objection is taken, then the matter may come up tomorrow, then I will.
Tomorrow,
Lordship.
at the request of the would-be appellant, comma, let the matter stand over for the day. Yes.
From the main list, item number 1.
PIL, what is this about, Mr.
Joy matter.
My lord, joy matter, my lord. Garbage. Yes,
Joy
my lord.
matter.
Yes.
Yes.
Lordship, I filed an affidavit dated 12 May 2023.
12th May.
2023, Your Lordship, when,
Yes.
as per the report submitted by different YH of the Joy urban area, it has been shown that compliance has
There's
not been
12th
given.
of April we see,
12th of May, Your Lordship.
then 15th of May. There's an order of 12th of April, 12th of May.
12th of.
Why are they in different places? Oh, supplementary, not orders. Yes.
Your Lordship, as per the affidavit and the report received from the different Durbar Snong under the jurisdiction of the Wahid Snong, Your Lordship.
Cannot really follow what you're saying.
Your Lordship, respondent number 5 and 6 have filed an affidavit bringing record their schedule
Yes.
of collecting the garbage.
Yes.
Whereas, as per the report received from the petitioner from different Wahid Snong,
Where is your report?
at annexure 1 of the affidavit dated 12 May 2023. Page number 6.
Page
6.
6. A record of the collection by Joai Municipal. Who has issued this report?
Report was issued by the General Secretary based on the report received from the different representative of the Durbar Snong, of the Wahid Snong, Your Lordship, of different localities.
Yes. Mr. Bhattacharya, this is alarming.
My Lord, Municipal Board has filed an affidavit, my Lord, given the details of the schedule, my Lord.
Where is that?
My Lord, this is affidavit dated, my Lord, 25th of April. Additional affidavit dated 25th of April, my Lord. My Lord, that page 5 is the schedule, my Lord, which has been prepared with a proper timeline
Yes.
of, my Lord, the vehicle number, the timing, specific timing at a particular locality, my Lord.
It's that document dated 17th March.
Yes, my Lord. 17th March.
But they've been clamoring throughout that, this is not happening.
Correct, my Lord.
And right now they have affirmed an affidavit relying on a record which is given by some official, which shows that there were only 3 days in some areas and most areas only 1 day.
My Lord, along with this affidavit, my Lord, at page 7 onwards, I've enclosed the photographs, my Lord, with the specific time and date on which the garbage are collected, my Lord.
Photographs prove nothing. How can we rely on these photographs? How do we know the photographs were taken?
Yes, my Lord.
When they were taken, where they were taken? They prove nothing.
That is why, my Lord, we had issued a letter to the Association of the Headmans on 15th of May, calling for a meeting on 18th of May to look into the matter. We have to cooperate.
There is a headman who has filed a report, and that report has been relied in an affidavit which shows an alarming picture.
My Lord, without any substantiating document, my Lord, it's just a statement, my Lord. That is why we called for a meeting on the 18th, my Lord. Only 2 of them landed up, my Lord. Now, my Lord, this is in public interest, my Lord. They are headmen, my Lord. We are willing to sit together and ensure that the work is done, my Lord.
Mr. Bhattacharya, that's why we asked you to intervene.
My Lord, so far as my instruction is concerned, my Lord, municipal is implementing the schedule honestly, my Lord. Now, so far as Wahid Snong is concerned, my Lord, a submission was made before this honorable court in the earlier occasion. A WhatsApp group was created, my Lord, where the headman and the official of the municipal are also there, my Lord. And my Lord, it was agreed upon that if in case there is any default, my Lord, they will first report it there. Nothing has been done, my Lord. At least their affidavit doesn't say so. My Lord, this schedule has been prepared.
Who has affirmed an affidavit to say that?
Look, we have put it.
Municipality could have filed an affidavit.
It's on affidavit.
In that affidavit, have you referred to the WhatsApp group?
Yes, my Lord.
And no.
It was there, my Lord. It is an earlier round of litigation. It is there. So earlier affidavit is there. Kindly, my Lord, see affidavit
And why haven't you attended the meeting that was called? You can't just complain and not do anything about it.
Will instruct accordingly, Your Lordship.
Recent affidavits have been filed, both by the Jawai municipality and by the petitioner in this public interest litigation, indicating completely different pictures of garbage collection in the town of Jawai, till such time that a permanent solution is reached. Paragraph. The Jawai Municipal Board relies on an order published on March 17, 2023, indicating the days of the week, the type of waste, the vehicle number, the timings at which it would be parked at different localities, and the names of the drivers and attendants who will be who are assigned to the relevant trucks. Full stop. The municipal board insists that such schedule is being strictly adhered to. Full stop. In support of such contention, a number of photographs have been relied upon, claiming massive garbage collection from different areas. Full stop. Despite the municipal board's affidavit, the General Secretary of Singjuk Ki Wahe Shnong, Jawai, has affirmed an affidavit claiming that there is hardly any collection of garbage, much less adherence to the schedule referred to by the municipal board. Full stop. A report prepared by the secretary of the Shnong has been appended to such affidavit. Full stop. Such report seeks to make out that in some of the areas, garbage has been collected only one or 2 days a month, and in certain areas there has been no collection of garbage at all. Full stop. Though the report reveals that the position may have somewhat improved in March, again, in April, a couple of areas were apparently not visited by the relevant trucks. Paragraph. Both the state and the municipal board dispute the purported record of collection of waste sought to be relied upon in the affidavit filed by the Shnong on May 12, 2023. According to the state and the municipal board, a WhatsApp group had been formed with the headmen of the various areas being part of the group, together with representatives of the municipal board, so that any failure to adhere to the disclosed schedule would result in complaints being made, full stop, the municipal board says that no complaints have been received pertaining to the schedule that was published on March 17, 2023, not being adhered to, full stop. Paragraph, the state supports the stand taken by the municipal board, full stop. In addition, comma, the municipal board claims that because certain difficulties may have arisen, comma, though not relating to the failure to adhere to the schedule published on March 17, 2023, comma, the municipal board called a meeting of all the headmen so that effective discussions could take place and the matter of removal of wet and dry waste in the town of Jawai could be dealt with, full stop. The municipal board reports that only 2 of the headmen attended such meeting, comma, despite all the others being informed thereof, full stop. Paragraph, the state should convene a meeting of both the relevant representatives of the municipal board and the headmen of the areas headmen of the localities in Jawai town, full stop. The state, comma, through the office of the Deputy Commissioner, comma, should ensure that the schedule published by the municipal board on March 17, 2023 is being adhered to, full stop. Any junior officer in the office of the Deputy Commissioner may make surprise visits and report to the Deputy Commissioner for the Deputy Commissioner to file a report when the matter appears next, a fortnight hence. Full stop. In the meantime, comma, the municipal board will indicate a date towards the end of this week where all the headmen should convene and discuss the and try to resolve, try to effectively resolve the impasse. Full stop. Give it a date after 2 weeks. But Jawai town doesn't look dirty for whatever reason. I've been through it twice. It doesn't look as dirty as it used to be a few months back. Yes.
Item number 2.
Ready for the kill? Yes.
After the last date of hearing, I had structured the submissions in terms of what was observed by your lordship.
Yes, just a thing. You of course will argue your entire case.
Lordship, please.
There we can't stop you. But again, you know what we want you to do is that in the list of many, let the deserving also not be lost. There could be a few grounds where you may have a stronger case, but if those get lost in 20 other useless challenges, then of course, you know, the court may paint in the same brush. So concentrate on what you think is, and the others also you do it. We'll have to deal with all the arguments.
I'm deeply obliged.
And please forget that there has been a previous hearing because you start from the beginning. Show us which of the grounds you're invoking under section 34. show us the express or implied prohibition under the contract, and then show us the award. That's your case.
Lordship pleases. So I have structured my submissions, my lords, under three broad heads. One is, my lords, insofar as the finding of the arbitrator with regard to certain heads get covered under an express contractual bar. So that's the first category. The second, my lords, a contention categorically raised, which goes to the root of the matter, is not dealt with by the arbitrator. So the second part is it being non-reasoned. And the third part is relevant contractual provisions have been either ignored or some implied provisions have been inferred, which tantamount to rewriting the contract, or the interpretation on the contractual provision is such that no reasonable man can adopt that interpretation. These are the three broad categories. Now, my lords, I start with the first category.
It has to be that high test.
Yes.
It's not possible.
That's correct. It's
not probable. It's not possible.
It's not a possible view, Lordship, please. So I come now, my lords, first to the first category.
And your argument deals with all the matters?
That's right. Mainly in respect of Lot 1, my lords. Lot 1, because Lot 2, Lot 3, Lot 4 will basically follow the view that your Lordship takes on Lot 1.
Just tell us this Lot 1, Lot 2 or whatever. Just give us the introduction a bit once again so that... No, you don't have to read anything. Just give us an introduction, brief introduction so that...
So in the synopsis itself, my lords, it's culled out. Lot 1 is civil works for the diversion tunnel, intake gate shaft, low-level intake, low-level gate shaft.
Just a second.
It's set out in the synopsis itself.
Where is the synopsis?
Page 1, my lords, the first page after the index.
The synopsis is part of your petition?
The appeal paper book.
Okay. This one should be there. This one should be. This one. Which has 117 paragraphs. Yeah, thank you.
It's the first page immediately after the index, my lord. It's the Roman 1 of the
Yes.
Your Lordship has that under synopsis. Lot 1, civil works for the diversion tunnel, intake gate shaft.
This place is called
Turiel. Lordship, please.
Yes.
Civil works.
Power station with 230 megawatt. Civil works for diversion tunnel, intake gate shaft, low-level intake, low-level gate shaft, diversion tunnel, and energy dissipation structure. Yes.
Lot 2 is my civil works for the dam, spillway, and saddle dam. Lot 3 is civil works for the powerhouse, tunnel for the power waterways, second stage concrete for power intake structures, and low-level outlet. Civil works in connection with installation of steel liner, gatehouses, and trash rack cleaning machine. Lot 4 is all hydro-mechanical equipment for the project. Lot 5 is electrical mechanical equipment consisting of generating units, transformer, switching equipment, and other powerhouse auxiliary equipment, and works in each connection.
Yes.
Now lots 1 to 3 were awarded to the present respondent.
Yes.
And the other two appeals, so the first three appeals are lot 1, lot 2, lot 3, and the other two appeals are in relation to construction of a road project. That is different from lot 4 and lot 5.
So, two other appeals
Lordship, please.
pertain to road construction.
Lordship, please.
And the same respondent.
Same respondent.
Same respondent.
Lordship, please.
Very good.
This is, my lords, the construction of the road to the dam.
So how can the grounds be the same? Lot 1, lot 2, lot 3, the grounds may be the same. But
There's some amount of overlap, my lords, I'll explain. But first, because the facts are a little involved, I'll just concentrate first on lot 1.
yes,
Now, insofar as the award is concerned, under the broad caption of express bar, your lordship will see the award on interest. That's at page 131.
so what are the express bar?
Yes. So
Headings.
interest, my lords, very clearly is expressly barred.
One, interest.
Lordship, please.
Any other ground?
The other, my lords, even, my lords, explosives, the delay in supply of explosive will also fall within that category.
Delay in supply of explosives.
But along with the express bar submission in respect of explosive, there is also a submission with regard to patent illegality in the context of the award being non-reasoned and contrary to two clauses of the contract.
Very well.
Then, so far as short supply of cement and steel is concerned, there is also a submission on express bar. In addition to, my lords, the other two submissions that I had just articulated for the previous item.
Short supply of cement and
Non-supply, delay in short supply of cement and steel.
cement and steel.
The next category is, my lords, tunnel collapse, where my submission is, my lords, that the award suffers from patent illegality.
Yes.
As no argument was raised on this question before the arbitral tribunal,
Yes.
and despite the onus being on them to prove that the design that we had provided was deficient, the onus is cast on us. The next is, my lords, under the head rock strata deviation and tunnels. The submission is also, my lords, on an express bar.
Yes.
And with regard to patent illegality, as interpretation of certain other clauses which supplement the express bar are interpreted in a manner that is, it's not even a possible view that can be taken.
Yes.
The next category is, my lords, extraction of boulders. The submission based on this is that there's an implied bar. I wouldn't say there's an express bar. and on the interpretation not being a possible one. The next, my lords, is excess roads. There the submission is only, my lords, on the basis of the interpretation not being a possible one.
These 7 heads.
Lordship, please.
Very good.
And the last is, my lords, construction drawing. Delay in issuing construction drawing, where the submission is that it's non-reasoned because correspondences cited are referred but not dealt with. There is also an overarching submission with regard to splitting up of the references. Our submission is, my lords, that when the High Court had directed that both references were to be heard together, it had seen the possibility of an overlap between the two periods. And therefore, since the second reference has gone to another panel of arbitrators, it would have been appropriate that both the references are decided by the same panel. So that's an overarching ground. And so far as the second reference is concerned, matters are at the stage of final hearing before the other arbitral tribunal. Now, with regard to the express bar clauses, earlier I had given Appendix A. There were certain clauses which were omitted out of Appendix A, which were just culling out the relevant contractual clauses. So I prepared another appendix, that is Appendix C. If your Lordship permits, I can just hand it over. Madam. I had also prepared a short note of submissions, my lords. Now, the relevant clause, my lords, insofar as interest.
Just a sec. This is in lieu of
interest. Page 1 of
we have over here is we have one which is called Lot 1. All of them are called Lot 1. One is a list of dates.
Yes, that has Appendix A.
A has list of contractual provisions.
Yes. And for the prohibitory clauses, I have separately culled out whatever was left out of Appendix A. I have just handed over Appendix C to your Lordship.
So this should go in over here, along with this. Now, other than that, what we have is additional documents, volume 1.
That has the award.
That has the award.
Yes.
Only the award.
Only the award.
Then additional documents. Volume 5.
What is that?
Which has copy of meetings. Third hearing, second hearing, first hearing.
But they are more on the submission of bias, my lords.
Wait, that you'll repeat.
So I will only, my lord, show your Lordship Appendix A, Appendix C, the main appeal paper book which has the impugned order, and the award which is the additional document.
And then there's an Appendix B. And there's a compilation of authorities.
Yes, Appendix B also your Lordship may ignore because they are mainly the bias appendix.
Yes. Now, you're taking the point of bias, are you not?
Because I am instructed to take it, yes.
Yes, so if you take the point of bias, then you show us bias, then we'll...
Yes, on the last date, my lords, I had made my submissions with regard to bias. I can...
No, you have to, because we are doing it afresh.
Very well.
You know, this gap of last will not do.
Lordship,
so we'll
please.
do that. So you finish your bias
Very well.
and then go into the merits.
And
And if you've lost us on bias, you've lost us on merits.
I'll start with the prohibition point, Mulad.
Very well. But whatever you have to say on bias, say it afresh.
Very well. Because the clause with regard to interest is in Appendix C at page 1.
Yes.
May I read that? Time for payment and interest, clause 55, Madam.
Or in any other respect whatsoever.
Lordship, please. The emphasis is mine on. No claims for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation owing to any dispute, difference or misunderstanding between the engineer in charge on the one hand and the contractor on the other, or with respect to any delay on the part of the engineer in charge making periodical or final payments, or in any interest, in any respect whatsoever.
So this is, the prohibition is on the corporation.
Yes. Now, this clause, a similar worded clause, Manoj, has been interpreted
Ambika.
in a recent judgment, Manoj. If I may just hand that over. This is Manoj Jaiprakash Associates.
Which has referred to Ambika.
Yes.
Yes.
Because there are three Ambikas. Two by Justice Mishra, one by, I think, Justice Chandrachud.
Lordship, please. It's all right. We have a protocol. Your Lordship first has paragraph 3 of this judgment. That's at page 791.
Yes.
It may be pointed out,
What is the reference?
this is Malod's 2019 17 SCC, page 786.
Yes.
Your Lordship may see paragraph 3, Malod.
Yes.
It may be pointed out that on interpreting clauses 50 and 51 of the general conditions of contract, the view taken by the High Court is that the clauses categorically provide that no interest would be payable to the contractor on the money due to him. The said clauses read as under. Clause 50, interest on money due to the contractor. No omission on the part of the engineer in charge to pay the amount due upon measurement or otherwise shall vitiate or make void the contract, nor shall the contractor be entitled to interest upon any guarantee or payment in arrears, nor upon any balance which may, on the final settlement of this account, be due to him. Clause 51.0, no claim for delayed payment due to dispute, etc., no claim for interest or damage will be entertained or be payable by the corporation in respect of any amount or balance which may be lying with the corporation, owing to any dispute, difference or misunderstanding between the parties, or in respect of any delay or omission on the part of the engineer in charge in making intermediate or final payment, or in any other respect whatsoever. The award makes the following observations in this behalf. As seen from the above, clauses 5, 50 and 50.1 of the contract deny interest on the claimant's dues by the respondent due to dispute, etc. However, as per quoted judgment of the Honorable Supreme Court of India, the claim for interest can be considered by the arbitral tribunal. Notwithstanding the same, the learned arbitrators granted interest by relying on the law declared.
Engineers' space is no longer good law.
Yeah. Lordship, please. Then I move on, my lords, to paragraph 6. As stated above, the High Court, on the other hand, had taken the view that if interest is prohibited as per the express terms of the contract between the parties, the arbitrator does not get jurisdiction to award interest. Further, insofar as interpretation to the aforesaid clauses is concerned, the High Court noticed that these clauses were on the same terms as clauses 1.2.14 and 1.2.15 of the contract, which were subject matter of the Construction and Theory Hydro Development Corporation versus Jayaprakash Associates. In the said judgment, this court had categorically held that those clauses to mean that no interest was payable on claim for delayed payment due to the contractor. Therefore, the same construction needs to be given to clauses 50 and 51 of the general conditions of contract in the instant case. Thereafter, my lords, the discussion, it starts at 13.3. If your lordship has page 796, because their lordships discuss the position under the old act and the new act and say the position under the new act is drastically different. 13.3 there after that discussion, my lords. Conversely,
You have a better copy. This is
sorry, my lords. We'd given the books also, my lords. I'm so sorry, my lords. I apologize.
Can't read it. Yes, go on.
Lordship, please. 13.3, my lords, is at 796. Conversely, if the agreement between the parties.
The history. GC Roy is the state of irrigation. Secretary Irrigation, Odisha.
That's right.
Yes. Then Said Ahmed.
That's right.
Those are all cases in the line of engineers' displays.
Lordship, please. And then, my lords, ultimately.
Where is Ambika considered?
Page. Page 797. If your lordship sees the quotation.
797.
Paragraph 16, relying on the decision of this court and Ambeka Construction.
Yes.
If I may read paragraph 14, my lords, in its entirety. The aforesaid position is reiterated. In Shri Kamachi Aman Construction, Union of India versus Bright Power Projects, later judgment is by a bench of 3 judges. This legal position is reiterated in Chitranjan Maiti versus Union of India, which is authored by one of us. In that case, the court considered the very same question which falls for determination by us, namely whether an arbitral tribunal was justified in awarding interest on delayed payments in favor of the appellant. After noticing that clause 16(2) of the GCC in this case bars payment of interest, it was held that under the 1996 Act, the position wherein is different from the 1940 Act. Interest could not be awarded. Following the observations from this judgment may be noted. Relying on a decision of this court in Ambika Construction versus Union of India, the learned counsel for the appellant submits that the mere bar to award interest on the amounts payable under the contract would not be sufficient to deny payment on pendent elite interest. Therefore, the arbitrator was justified in awarding pendent elite interest. However, it is not clear for Ambika Construction as to whether it was decided under the Arbitration Act 1940, for short the 1940 Act, or under the 1996 Act. It is relied upon a judgment of the Constitution Bench in Irrigation Department, State of Orissa versus GC Roy. This judgment was with reference to the 1940 Act. In the 1940 Act, there was no provision which prohibited the arbitrator from awarding interest for pre-reference, pendent elite, or post-award period, whereas the 1996 Act contains a specific provision which says if the agreement prohibits the award of interest for the pre-award period, the arbitrator cannot award interest for the said period. Therefore, the decision on Ambika construction cannot be applicable in the instant case. Sorry. That's right.
That Ambika, 2017 Ambika,
yes,
later went to a larger bench.
yes,
And then there's paragraph 34 of Justice Arun Mishra's judgment.
Lordship, please.
34 or 35. There's a later Ambika. And that Ambika has been interpreted by Justice Chandrachud.
Lordship, please. In fact, paragraph 24, that's Ambika 2.
24.
Sorry, paragraph 16, where there's a quotation of paragraph 24.
Yes.
If your Lordship sees between placitum F and G,
Yes.
thus when one contrasts the clause, such as the clause in the second Ambika construction case, with the clause in theory hydro development, it becomes clear that unless a contractor agrees that no claim for interest will either be entertained or payable by the other party owing to dispute, difference, or misunderstanding between the parties in respect of delay on the part of the engineer, or in any other respect whatsoever, leading the court to find an express bar against payment of interest, a clause which merely states that no interest will be payable upon amounts payable to the contractor under the contract would not be sufficient to bar an arbitrator from awarding pendente light interest under the 1940 Act. It has been held in the first Ambika construction case that grant of pendente light interest depends upon the phraseology used in the agreement. Clauses conferring power relating to arbitrator, the nature of the claim and the dispute referred to the arbitrator, and on what items the power to award interest has been taken away and for what period. We hasten to add that the position as has been explained in some of the judgments above under section 31(7) of the 1996 Act is wholly different inasmuch as section 31(7) of the 1996 Act sanctifies agreements between the parties and states that the moment the agreement says otherwise, no interest becomes payable right from the date of the cause of action until the award is delivered. In this whole conspectus, and keeping in mind that the present case is regulated by the 1996 Act, we have to decide the issue at hand. At this stage itself, it may be mentioned that in case clauses 50 and 51 of the GCC put a bar on the arbitral tribunal to award interest, the arbitral tribunal does not have any jurisdiction to do so. As pointed out, right from the stage of the arbitration proceedings till the High Court, these clauses are interpreted to hold that they put such a bar on the arbitral tribunal. Even the majority award of the arbitral tribunal recognizes this, notwithstanding the same it awarded interest by relying upon Port of Calcutta case. The High Court, both single bench as well as the division bench, rightly noted that the aforesaid judgment was under the 1940 Act, and the legal position on this behalf have taken a paradigm shift, which position was clarified in Saeed Ahmed and Company case. The rationale given by the High Court is in tune with the legal position, which stands crystallized by a catena of judgments noted above. The other reason given by the High Court is equally convincing. Clauses 50 and 51 of the GCC are paramateria with clauses 1.2.14 and 1.2.15 of the GCC. In the THDC case, these clauses have been interpreted by holding that no interest is payable on claim for delayed payment due to the contractor. Same construction adopted in respect of these clauses, which in fact is a case between the same parties, is without any blemish. In this backdrop, the only argument of the appellant remains to be considered is whether such a construction is contrary to the judgment in Harish Chandra case. Complete answer to the first argument is provided in Reliance Cellulose Products Limited. Following the discussion contained therein, which discussed THDC, the judgment would amply demonstrate this. Also, unlike the Tehri Hydro Development Corporation, Clause 16 does not contain language which is so wide in nature that it would interdict an arbitrator from granting pendente light interest. It will be remembered that the clause in Tehri Hydro Development Corporation spoke of no claim for interest being entertained or payable in respect of any money which may be lying with the government owing to dispute, difference or misunderstanding between the parties, and not merely in respect of delay or omission. Further, the clause in Tehri Hydro Development Corporation goes much further and makes it clear that no claim for interest is payable in any other respect whatsoever. It is pertinent to mention that the aforesaid judgment also discusses and analyzes Harish Chandra case. In the first place, the judgment in Harish Chandra case is under the 1940 Act. More pertinently, this judgment is explained and distinguished in Saeed Ahmed in the following paragraphs. The appellant strongly relied upon the decision of this court in State of UP versus Harish Chandra and Company to contend that clauses 1.09 of the contract did not bar the award of interest. The clause barring interest that fell for consideration in that decision was as under: no claim for delayed payment due to dispute, etc. No claim for interest or damages will be entertained by the government with respect to any monies or balances which may be lying by the government owing to any dispute or difference or misunderstanding between the engineer in charge in making periodical or final payments or in any other respect. This whatsoever. This court held that the said clause did not bar the award of interest in respect of a claim for damages or for a claim for payment of work done. We extract below the reasoning for such decision. A mere look at the clause shows that the claim for interest by way of damages was not to be entertained against the government with respect to only a specified type of amount, namely any monies or balances which may be lying with the government owing to any dispute difference between the engineer in charge and the contractor or misunderstanding between the engineer in charge and the contractor for making periodical or final payments or in any other respect whatsoever. The words "or in any other respect whatsoever" also refer to the dispute pertaining to the monies or balances which may be lying with the government pursuant to the agreement, meaning thereby security deposit or retention money or any other amount which might have been with the government and refund of which might have been withheld by the government. The claim for damages or the claim for payment for the work done which was not paid for would not obviously cover any money which may be said to be lying with the government. Consequently, on the express language of the clause, there is no prohibition which could be culled out against the respondent contractor that he could not raise a claim for interest by way of damages before the arbitrator on the relevant items placed for adjudication. Then, my lords, if your lordship sees paragraph 21, it is also pertinent to note that the judgment in Saeed Ahmed and Company distinguishing the restricting wording in Harish Chandra has been consistently followed by this court in a number of cases thereafter. In this scenario, when we find that Harish Chandra's case, which is of the vintage of the 1940 Act, is distinguished in Saeed Ahmed, coupled by the fact that the ratio of Saeed Ahmed has been consistently followed, there is no reason to deviate from the construction to clauses 50 and 51 of the GCC given by the arbitral tribunal. Above all these, the clauses are in paramateria with clauses 1.2.14 and 1.2.15 of GCC in THDC case, which was a judgment between the same parties. Now, para 22, if your lordship would be pleased to see, it specifically negates the argument, my lords, based on adjustum generis, that this any respect whatsoever should be read adjustum generis with the previous part. Your lordship just sees paragraph 22. Insofar as the argument based on the principle of adjustum generis is concerned, the division bench has held that it is not applicable in the present case. We find it is rightly held. Adjustum generis is a rule of construction. The High Court had negated this argument in the following manner. And then it refers to Jai Prakash, as rightly held, the rule adjustum generis would be applied if there is a distinct genus or category which is lacking in the instant case. This rule is applicable when particular words pertaining to a clause, category or genus are followed by general words. In such a situation, the general words are construed as limited to things of the same kind as those specified. In that sense, the rule reflects an attempt to reconcile incompatibility between the specific and general words in view of the other rules of interpretation, that all words in a statute are given effect, if possible, that a statute is to be construed as a whole, and that no words in a statute are presumed to be superfluous. Therefore, my respectful submission before your lordship is this, that a similarly worded clause as the present one, that is clause 50 and 51, have been interpreted by the Supreme Court in a particular manner, and which would clearly imply that on the clause, my lords, under construction before your lordship, no interest would be payable, and the award insofar as interest is concerned is contrary to the express terms of the contract. That's my first submission. Now, my lords, in order to cement this submission, may I just show how the award, my lords, deals with this particular aspect. If your lordship sees how the award has dealt with this particular aspect, your lordship sees, my lords, the additional volume 1, it's dealt with at page 131. We had handed that additional volume over, my lords. Page 131. But the pages are at the bottom. Your lordship has, my lords,
Yes.
small Roman 5, which the head is interest, and if your lordship has the last 5 lines. The tribunal did not find any prohibitory clause in the contract regarding payment of interest on the sum due to the contractor. The arbitral tribunal notes that even where a contract, where general conditions of the contract provides that no interest will be payable upon inter alia amounts payable to the contractor under the contract, the court had held that it is well settled law that such a clause has to be strictly construed. The arbitral tribunal refers to the decision on Board of Trustees for Port of Calcutta, that's 1996 1 SCC 516. Where the Supreme Court, while dealing with such a clause, has stated that reasons for strict construction of such clause is that ordinarily a person who has a legitimate claim is entitled to payment within a reasonable time, and if the payment has been delayed beyond reasonable time, he can legitimately claim to be compensated for that delay whatsoever nomenclature one may give to his claim in this behalf. Dealing with the powers of the arbitrator to award interest for the post-reference period, the Supreme Court has pointed out, once the matter goes to arbitration, the discretion of the arbitration not in any manner stifled by the terms of the contract, and the arbitrator would be entitled to consider the question of grant of interest pendent allied and award interest if he finds the claim to be justified. We are therefore of the opinion that the clause of the contract, the arbitrator, was in no manner prohibited from awarding interest pendent allied. In the same decision, it was also held that matters relating to construction of such a clause was a matter which fell within the jurisdiction of the arbitrator. Section 31(7)(a) of the Act expressly authorizes the arbitral tribunal to award interest for the period between the date when the cause of action arose and the date of the award, except that the rate of interest cannot be more than what is agreed to between the parties, if there is an agreement. Secondly, Section 31(7)(b) of the Act permits grant of interest of 18% per annum from the date of the award till payment. Therefore, my lords, the substratum of the reasoning in the award is Port of Calcutta, which is a judgment under the old Act, which is specifically referred to in Jayaprakash. And in Jayaprakash, my lords, the award referred to Port of Calcutta, and that award was set aside. So this is the only reasoning, my lords, of the learned arbitrator, to say that even if there is a prohibition under the contract, there is a discretion to award interest, which, my lords, position is palpably illegal in view of, my lords, the express language, my lords, of Section 31(7), as well as, my lords, the judgment that I just referred to. Now, the impugned order, my lords, if your lordship goes to the appeal paper book, deals with this particular contention at page 822.
How big is the impugned order?
It's about, my lords, 64 pages, I think.
It begins with 767.
Effectively begins at 776 up to
822.
838. Your Lordship has the head, interest awarded to the respondent. The petitioner has contended that under clause 55 of the contract, there is a specific prohibition to claim interest for the pre-reference period, and also the rate of interest awarded by the arbitral tribunal is highly excessive and is not in line with the current bank rate of interest. In this regard, it is stated that once it is considered that an arbitrator has power to grant interest and has also discretion in granting interest at a particular rate, provided it is reasonable, the award of the arbitrator cannot be held to be bad in law or interfered with on the ground that he could not have granted interest or could not have awarded it at a particular rate unless the court is convinced that the grant of interest was not at a reasonable rate. Reliance is placed on the decision of the Honorable Supreme Court in Manalal Prabhudayal versus Oriental Insurance Company. In this regard, further reliance is also placed on the judgment in the case of State of Uttar Pradesh. In this regard, the petitioner relied upon Saeed Ahmed and Company, which is distinguished in the Harish Chandra case. The restriction on the payment of interest under clause 55 of the contract is very specific, one which only provides that no interest will be entertained by the corporation with respect to any money or balance which may be lying with the corporation. There is absolutely no bar on the arbitrator's powers to grant interest in the manner granted in favor of the respondent, vide the arbitral award. As such, this clause 55 cannot be considered to put a bar on an arbitrator's power to grant interest under section 31(7) of the Act. Well, as for the reasons that I had stated earlier, in my respectful submission, the construction on clause 55 is wholly incorrect, Malaz, and is not in the manner, Malaz, which construed by the Honorable Supreme Court, Malaz, and Jai Prakash. Therefore, Malaz, clause 55, in my respectful submission, is an express bar to the award of interest by the arbitrator. So this is my first respectful submission. This is done. So just keep it. The law. Yeah. Yes. Yeah. Now, before I come to Malaz, the other aspects, that is explosives, short supply of cement, etc. My respect, I may just state, Malaz, as to what my understanding of the applicable law for the purposes of considering the correctness of awards is concerned. In my respectful submission, Malaz, section 34(2)(b), explanation 1 to capital A would be the applicable law. That is the law, Malaz, as amended in 2015. So to construe even awards which are prior or thereafter 2015, in my respectful submission, the applicable law would be the amended law. Your Lordships are aware, the old law, that is the unamended law, was a little wider. So this is Malaz, a submission that I make with prejudice. That is to say that in view of the judgment of the Honorable Supreme Court, Malaz, in BCCI versus Kochi, as thereafter, Malaz, explained in Hindustan Construction, where your Lordships are aware that the basis of BCCI versus Kochi was sought to be removed by section 87. Hindustan Construction, Malaz, strikes down section 87 as well. So, based on the principle laid down both in BCCI versus Kochi Cricket as well as Hindustan Construction, The applicable law in my respectful submission would be section 34 as amended in 2015. Yeah, because my lords, in this case, the section 34 is filed post the amendment.
Correct, post 23rd of August.
Yeah. My lords, I can take your lordship through those decisions if necessary, but the law is sufficiently clear, my lords, on that aspect. So if I may just show your lordship section 34.
Yes, it disregards that Justice Nariman's judgment, disregards paragraph 26 of the amending act.
Yeah.
It interprets it.
It interprets that.
It will read, but it
So my lords, there are two.
Because paragraph 26 clearly said that this will not apply to any arbitration or any reference which has been made, not the date of the award, but a reference or something like that. And the judgment is contrary to that.
Yeah. What happened is,
Both Kochi and the Hindustan Constitution.
lordship, please. So in Kochi, section 26 of the amended act called for
Of the amending act.
called for interpretation. And my lords, it was interpreted in BCCI versus Kochi to say that the new act, that is the post 2015 amending act, will apply, notwithstanding the wording of section 26. Now, after that, Kochi Cricket also noticed the proposal to bring in section 87, your lordships are aware, and said that this would be something that the legislature should very seriously consider and will not be in public interest, because it will further delay implementation of awards. Notwithstanding that, my lords, 87 was brought in to undo actually the effect of a BCCI versus Kochi, because probably the government had an anxiety, they wanted a slightly wider jurisdiction under section 34 to consider awards which were made in respect of arbitrations prior to 2015. That has been further, my lord, struck down in Hindustan Construction. So 87 is struck down in Hindustan Construction to say that this is wantonly arbitrary, manifestly arbitrary, and therefore all of 87 goes. So therefore the position which endures today is that to consider the correctness of this award, the law as it stands post the 2015 amendment would be the relevant law. That's my respectful submission.
When was the challenge to the, what is the date of the award?
The date of the award, my lords?
21/08/16.
21st of August 2016. So that's also post. So I can take your lordship through the relevant law if necessary. Yes, ma'am. May I first refer, my lords, to Kochi Cricket, that is 2018, 6 SCC, page 287. My lords, I have prepared a compilation of judgments, my lords.
In which that interest judgment is not there.
Unfortunately, my lords, that was missed.
Yes.
Kochi Cricket, my lords, is the first one, my lords, printed page 1. Your lordship first comes to page 13, print page 13.
Despite his erudition, there are two judgments of Justice Nariman that I don't agree with. One is this, but this becomes binding. In the High Court, I can't do anything about it, it's binding on me. The other one is completely erroneous, is where he places emphasis on place of arbitration as a relevant consideration. Because that entirety is taken from paragraph 95 of Kaiser versus Balco, and Kaiser versus Balco, as you know, is a foreign arbitral award. So foreign arbitral award, municipal law does not apply, and he's just quoted, so that's completely, that's per incurium, not even obiter dicta, it's per incurium, in which he has imported into his judgments, and without referring to the parent judgment, which is Hakam Singh Gammon India, where, under section 28 it was challenged that place of, you cannot have a agreement, forum selection clause. So then Hakam Singh Gammon India says, and which is the part where, Justice Nariman does not consider, that if two courts had the jurisdiction to receive the list, then parties by agreement can confer exclusive jurisdiction on one court. But if the court conferred with the jurisdiction did not possess the authority to otherwise receive the list, then the parties by agreement cannot confer jurisdiction. This principle was not, noticed when he imported that precedence, because in municipal, in foreign law, what happens is, international law, when you go to Switzerland, you don't go to Switzerland because the backdrop of the Alps. When you go to Switzerland, you embrace, unless, there can be law of the contract, law of the arbitration agreement, law in which the arbitration will be conducted, and law dealing with matters arising out of the award. Generally, the curial law that you follow, unless specifically agreed, is the law of the place where you go to. You can contract to the contrary. You can have, for instance, an arbitration in London and provide that Indian Arbitration Act will govern as regards challenge and not the English Arbitration Act. But sans a contract to that effect, when you go to England, when you go to Switzerland, when you go to Canada, the challenge has to be under that. That is because the law differs from place to place depending on not the venue of the arbitration, but the seat of the arbitration. Venue is something you can change. Seat is something you cannot change. So once the seat is identified, the law is identified unless you contract to the contrary. In municipal law, whether you have an arbitration in Bombay or Delhi or Shillong or Calicut, the law is the same. And therefore, the mere seat of arbitration does not attract anything special. There are many things which are principles. Fundamentally, international law and municipal law are diametrically opposite. For instance, place of death, matter of inheritance, marriage. Municipal law and international law are completely opposite on principles. So this is where this of course is binding, but that I have distinguished and said is per incurrum.
The BGA's SJ Soma, that's the judgment.
I don't know, it's Indian Rayon or something, Indian Commerce, IFCO.
IFCO, my lord, is a case of limitation. So that's not the case, where he says that you can, actually there can be an interim award on limitation. That's a different one. BGA's SJ Soma is the one my lord is referring to.
Which one is that?
That's the one. Where he says, my lord, the seat is the center of gravity regardless of...
Because 2(1)(e) as it is now is no different from 2(c) as it was in the old. And what 2(1)(e) requires is that, in simple terms, if you could have filed a suit in a particular court, then you can also file an arbitration matter in that particular, a section 9 in that court.
That's right.
And that, under the old act, you had to read it with section, I think, 30 of the old act, or 31 of the old act. Now you have to read it with section 42 of the new act. But this one is, of course,
I don't know.
Yes, let us see where he says that.
Lordship, please. Please see page 13 first, my lord. Just at the beginning of the judgment.
Yes, sir. (13).
Yeah. The present batch of appeals raises an important question as to the construction of section 26 of the arbitration and Conciliation Amendment Act.
Arbitral proceedings commenced.
Yes. Act not to apply to pending arbitration proceedings.
Yes.
So this is why 26 has been set out. Thereafter, your lordship goes straight to page 38, print page 38, paragraph 58, my lord. Yeah.
Yes.
From a reading of section 26 as interpreted by us, it becomes clear that in all cases where section 34 petition is filed after the commencement of the Amendment Act and an application for stay having been made under section 36 therein will be governed by section 34 as amended.
Very well. Very well.
Yeah.
Contrary to section 26 Amending Act.
Lordship, please. I can take your lordship through the reasoning, but it's not necessary.
No, not necessary.
Lordship, please. And then
Binding.
Lordship, please. And then ultimately, if your lordship just comes
HCC.
to page 52, just of this very judgment, my lords. Your lordship sees paragraph 78.
Which is Hindustan Construction.
No, which is this judgment where the proposed section 87 is noticed.
Page 52, you said.
Page 52, para 78.
Para 78.
Yeah. The government will be well advised in keeping the aforesaid statement of objects and reasons on the forefront if it proposes to enact section 87 on the lines indicated in the government's press release dated 7/3/2018. The immediate effect of the proposed section 87 would be to put all the important amendments made by the amending act on the back burner, as the important amendment made to section 28 and 34, in particular, which have been stated in the statement of objects and reasons, have resulted in delay of disposal of arbitration proceedings and increase in interference of courts in arbitration matters, which tend to defeat the object of the act, and will now be applicable to section 34 petitions filed after 23/10/2015, but will be applicable to section 34 petitions filed in cases where arbitration proceedings have themselves commenced only after 23/10/2015. This would mean that in all matters which are in the pipeline, despite the fact that section 34 proceedings have been initiated only after 23/10/2015, yet
Yes,
we hold.
yes. That proposed section 87.
Yeah.
Yes.
Now straight away, my lords, I'll come to HCC. That Hindustan Construction, it's at page 70. Your lordship comes to 107 to 109, ink page 107 to 109.
Yes.
Para 60. The Shri Krishna Committee report is dated 37/2017, which is long before this court's judgment in Kochi cricket case. Whatever uncertainty that may have been because of the interpretation by different high courts has disappeared as a result of Kochi cricket judgment. The law on section 26 of the 2015 Amending Act being laid down with great clarity. To thereafter delete this salutary provision and introduce section 87 in its place would be wholly without justification and contrary to the object sought to be achieved by the 2015 Amendment Act, which was enacted pursuant to a detailed Law Commission report which found various infirmities in the working of the original 1996 statute. Also, it is not understood as to how uncertainty and prejudice would be caused, and they may have to be heard again, resulting in an inconsistent position. The amending law would be applied to pending court proceedings, which would then have to be disposed of in accordance therewith, resulting in the benefits of the 2015 Amendment Act now being applied. To refer to the Shri Krishna Committee report.
Paragraph 63 struck down.
Lordship, please.
Yes.
Yeah. This very principle, my lords, in Patel Engineering, which is a case between the same parties, but with regard to an earlier award, your lordship just has one particular portion This is, my lords, very same compilation, page 56. At I don't want to go through all that.
Just para 50.
Yes. No, we are right now not on patent. Yeah. In paragraph 15, Malas, BCCI is referred to, that's at print page 62.
62.
Lordship pleases. Just paragraph 15. In BCCI, the Supreme Court has held that the Amending Act 2015 would apply to Section 34 petitions that are made after 23/10/2015. That is the day on which the Amendment Act came.
This is also Justice Nariman.
No, ma. This is, my lords, actually delivered by the bench. Justice Bhanumati,
yes.
Justice Indu Malhotra, and Justice Anirudh Bose. So there's one of those very few judgments where, in fact, I had the occasion of appearing, so judgment was reserved, but subsequently it was pronounced in the form of the order of the court. So if your lordship has seen paragraph 15.
Yes.
So then BCCI, the Supreme Court held that the Amending Act 2015 would apply to Section 34.
And then it refers to associate builders.
Yes. So therefore, my lords, what is held is that the very same tests of associate builders and Sangyong.
Does it refer to Sangyong?
Yes, it does.
It does, Sangyong.
Yes.
2019.
Yes. So as my learned junior rightly points out, my lords, Sangyong actually cut down the width of associate builders. So now it's basically the Sangyong principle which will apply. But patent illegality would be a ground.
But patent illegality is dealt with, I think, in paragraph 17 or so of associate builders, which reads a different judgment.
Yeah.
Because patent illegality had been interpreted otherwise in McDermott by Justice Sinha. And that was curtailed.
Yes.
That was curtailed.
Yeah.
And that is a judgment which is quoted in associate builders.
Lordship pleases. So Sangyong has been interpreted in this Patel engineering, if your lordship sees paragraph 20.
20. Yes.
In Sangyong Engineering and Construction Company Limited, this court was considering a challenge to an award passed in an international commercial arbitration between the appellant company, a foreign entity registered under the laws of Korea, and the respondent, a Government of India undertaking. In paragraph 19 of the judgment, this court noticed that the expansive interpretation given to public policy of India and Saw Pipes and Western Gecko International, cases which had been done away with, and a new ground of patent illegality was introduced, which would apply to applications under Section 34 made on or after 23/10/2015. In paragraphs 36 and 37 of the judgment, this court held that insofar as domestic awards are concerned, the additional ground of patent illegality was not now available under subsection 2A to Section 34. However, reappreciation of evidence was not permitted under the ground of patent illegality appearing on the face of the award. In paragraphs 39 and 40 of Sangyong, this court reiterated paragraphs 42.2 and 42.3 of Associate Builders, wherein it was held that the construction of the terms of the contract is primarily for an arbitrator to decide, unless the arbitrator construes a contract in a manner which no fair-minded or reasonable person would take. That is, if the view taken by the arbitrator is not even a possible view to take. In paragraphs 39 and 40, the Supreme Court held as under. To elucidate paragraph 42.1 of Associate Builders versus DDA, namely that a mere contravention of the substantive law of India by itself is no longer a ground available to set aside an arbitral award. Paragraph 42.2 of Associate Builders versus DDA, however, would remain. For if an arbitrator gives no reasons for an award, and contravene section 31(3) of the 96 Act, that would certainly amount to a patent illegality on the face of the award. The change made to section 28(3) by the Amendment Act really follows what is stated in paragraph 42.3 to 45 in Associate Builders versus DDA, namely that the construction of the terms of the contract are primarily for an arbitrator to decide, unless the arbitrator construes the contract in a manner that no fair-minded or reasonable person would take. In short, that the arbitrator's view is not even a possible view to take. Also, if the arbitrator wanders outside the contract and deals with matters not allotted to him, he commits an error of jurisdiction. The ground of challenge will now fall within the new ground added under section 34(2)(a). The present case arises out of a domestic award between the two Indian entities. The ground of patent illegality is a ground available under the statute for setting aside a domestic award. If the decision of the arbitrator is found to be perverse or so irrational that no reasonable person would have arrived at the same, or the construction of the contract is such that no fair or reasonable person would take, or the view of the arbitrator is not even a possible view. In the present case, the High Court has referred to the judgment in Associate Builders at length in paragraph 42 of its judgment, dated 26/2/2019, and arrived at the correct conclusion that the arbitral award can be set aside under section 34 if it is patently illegal or perverse. This finding of the High Court is in conformity with paragraph 40 of the judgment of this court in Sangyo. In the present case, the High Court in paragraph 60 has held that no reasonable person could have arrived at a different conclusion while interpreting clauses 2.7 and 3.4 of the BOQ and clauses 32(2)(a) and 33(3) of the conditions of contract. Any other interpretation of the above clauses would definitely be irrational and in defiance of all logic. Then, my lords, the judgment is extracted. The judgment of this court is extracted. If your lordship just sees between placitums D to E at page 67, the conclusion reached by this court was that the findings of the learned arbitrator have been arrived at by taking into account irrelevant factors and by ignoring vital clauses. The same suffers from the vice of irrationality and perversity. And then is ultimately the conclusion in paragraph 26 and 27. So I have cited this judgment for two reasons. One is, my lords, what is the applicable law? And also, my lords, in order to state...
Expound on patent illegality.
On patent illegality. That's the limited purpose, my lords, for which I cite this. Now, express bar, as your lordship rightly pointed out, can certainly be a ground. I have made my case with regard to interest. Now, my lords, I come to the second aspect with regard to explosives. Now, just keep that full supplementary agreement also ready, if you don't mind. Yeah. Now,
yes.
So far as, my lords, the award in respect of delay in supply of explosives is concerned, my lords, I'll just give your lordship the page number. The contention raised by us is at page 70 of the award. I'll take your lordship through the findings a little later, but I'll just giving your lordship the page numbers. Page 70, my lords, is the contention raised. The findings under this head are from page 95 to 97. Now, on the question of express bar, if your lordship just comes to page 7 of my Appendix C.
Yes.
Now, this is a supplementary agreement which was inked between both the parties. I have the whole of the agreement also here, Malad, but I didn't want to add to the papers. Your Lordship sees paragraph 1. Following materials shall be issued by the corporation to the contractor at the issue rates as mentioned against each item. And serial number 9 of that is explosive. But over the page, if your Lordship has, under general clause B. However, if any item of materials as mentioned above cannot be provided by the corporation in any time, it cannot be claimed as cause of delay by the contractor, and compensation or extra benefit whatsoever, except granting of time extension, will be entertained by the corporation. And the same thing is repeated in this book 2, clause B. However, if any item
will not be entertained,
but that's it should be meaningfully read. But even in the supplementary agreement, the word "not" is not there.
That's to your.
No, but Malats, it has to be meaningfully read.
Yes.
Otherwise, Malats, it shoots my fox gets shot, Malats.
It cannot be claimed as cause of delay by the contractor.
So,
and compensation or extra benefit whatsoever, except granting of time, will not be entertained.
What is there in the English? I know that. Before I said no. No.
Even your general conditions has the same mistake.
Yes, Malad. In fact, Malad, the mistake is crept in because what is said in the latter part is except granting of time, extension will be entertained. So you can be granted time extension. So that's why the word "not" is not put in there.
That cannot be claimed as cause of delay by contractor, and compensation or extra benefit whatsoever,
except granting of time extension will be entertained. So you won't get compensation, but we may grant you time extension. I think that's why the word "not" is not. It's clumsily drafted. Could have been better drafted. But meaningfully read.
This one, even the general one,
yes,
that cannot be claimed as case of cause of delay by the contractor and compensation or extra benefit whatsoever,
except granting
of time will
extension.
not be entertained.
That's right.
Yes.
So, in my respectful submission, so far as explosives is concerned, this falls within the fulcrum of an express bar, in my respectful submission. Now, may I take your Lordship through the relevant portion of the award to show that it is also non-reasoned, and two vital contract clauses which have a bearing on interpretation of the entire claim have not been properly considered.
Yes.
Your Lordship has the award,
Yes.
page 95 onwards. You want to show our contentions? Yeah. Your Lordship has the foot of the page under C. Delay due to non-issue of explosives as per requirements of the claimant as projected in the construction program. The contract provides that the respondent will supply cement, steel and explosives to the claimant at the issue rates subject to conditions as specified in Appendix 6, Part 3, Volume 1 of the contract agreement. The tribunal has gone through the submissions of both claimants and the respondents in this regard. The tribunal finds that the respondent itself does not have the license issued by the controller of explosives for permanent explosive magazine till 2002, that is for a period of more than 1 year from the start of contract work, and as such had to supply from portable magazine and arranging from PWD Mizoram. This aspect was not contemplated or provided for under the terms of the contract. The AT notes that the respondent's argument that under the contract provisions, non-issue of materials by the respondent at any time cannot be claimed as cause of delay by the claimant and compensation or extra benefit whatsoever except granting of time extension. So this particular clause is mirrored, as your Lordships have seen. The tribunal has noted that the respondent has granted provisional time extension on 29/12/2003 to 36/2004 with the right to recover compensation as per the contract condition, that is after expiry of the original time limit of 28/9/2003. There is no provision in the contract for granting provisional time extension under the relevant contractual provision for time of completion. The respondent failed to show to the tribunal from the records that the provisional time extension was finally termed as time extension under the contract. It is also an admitted fact that the work of Turiel HEP was suspended by letter dated 31/5/2005 with effect from 9/6/2004, even before the so-called provisional time extension had expired. The tribunal had placed reliance on the judgment and so and so. Time is the essence of the contract, etc. In view of this position, the tribunal accepts the submission of the claimant that there was delay due to non-issue short supply of explosives. Now, this is the only reasoning given by the tribunal. So first, this clause is expressly noticed. Your Lordships have seen the earlier part. I can understand the tribunal says it doesn't operate as a bar, but there is no reasoning on that count. And despite the fact the tribunal records all the submissions as having been made, it relies very heavily on the time extension that was granted. But that begs the question as to whether if time extension is even granted, even then nothing is payable. So time extension is the best that you can get if there was any delay in supply by the contract. So this aspect, despite being specifically urged, is not even dealt with. Now, on the aspect of delay also, the factual aspect of delay, on facts, my lords, your Lordship will not go into. Your Lordship is absolutely right. But at page 70, where I raise my contentions, I cite correspondence to say that, in fact, whatever explosives I supplied to you, the entirety of that was not even used by you. So there was never any shortfall. That aspect is also not dealt with here. The contention is recorded at page 70, if your Lordship just sees my contention. Please see, my lords, page 70, small Roman 5. As regards to the issue, my Lord Justice Dindo has that one. Yes. Yeah. As regards to the issue of non-supply or short supply of cement and steel, explosives is just Roman 5. As regards to the issue of non-supply or short supply of explosives, the respondent has averred as follows. The respondent denied the allegation of the claimant and pointed out that the record mentioned by the respondent at the project site revealed that there was adequate stock of explosive with the claimant at the end of most of the months, and there was no short supply of explosives. The respondent cited percentage utilization of explosives in the month of January, April, June to November 2002, which revealed underutilization of explosives. The respondent concluded that the claimant was not in a position of readiness to utilize available explosives, which delayed the project. The respondent pointed out that the claimant obtained explosive license for storage and usage of the same only on 28/11/2002 for 500 kg. Now this contention is raised, recorded. But please see, Malwats, I don't find even a line dealing with those contentions. So therefore, Malwats, my challenge insofar as explosives is concerned is on 3 grounds. One is the express bar that I pointed out. The second is contentions specifically raised which go to the question as to whether there was indeed short supply or not having been dealt with, and no reasons or findings returned by the arbitrator. And that therefore would, in my respectful submission, amount to patent illegality.
Why was the contract was terminated? They were not allowed to complete the work.
No, he completed the work.
Then why was it suspended?
Because what had happened is that in between, because of agitations, etc., there was a law and order issue. So, Malaj, we had pleaded force majeure during a particular period. So that is why it was suspended for some point of time. Now, this delay or this amount that is given is not under that head at all. Under this head of non-supply of explosives, the sum and substance of the arbitrator's finding is that because you did not supply explosives in time, during this it resulted in delay in the work. And therefore, for that I am giving you compensation. Now, so far as, therefore, under this head, in my respectful submission, nothing could have been awarded. For the simple reason, that firstly, factually, it was specifically pointed out that there was no short supply, you had an adequate stock. Second, the clause specifically prescribed an excess bar, saying even if there is short supply by me, you will be only entitled to extension of time, you will not be entitled to any compensation. And third is all these contentions are not even dealt with, so the award becomes non-reason to that extent.
These grounds are the pre-suspension period, therefore
yes.
Delay up to suspension.
Yes. So this ground is, my lords, all for a pre-suspension period, not during the period when the contract was suspended at all. So this is my respectful submission, my lords, on the aspect of explosives. Now I come to, my lords, the next head. Anything more you want to show? Just two contract clauses I wanted to show, my lords, which also have been missed by the learned arbitrator. Your lordship may kindly go to Appendix A, page 58.
This is cement and steel.
Just before that, my lords, just to complete my point on explosives, I just want to show your lordship 2 clauses.
Appendix A.
Appendix A, that's appended to the list of dates, my lords. So while the arbitrator, my lords, faults me for not getting an explosive license, even he didn't have an explosive license at the relevant point of time. Contention raised, not dealt with.
Where is that?
If your lordship just sees page 58 of the appendix. Explosive detonators would be issued by the contractor.
Page 58.
Page 58 of Appendix A.
At the bottom.
At the bottom. The pages are at the bottom.
Yes, page 58 is some affidavit.
Sorry, Malad. I think has your Lordship got my list of dates?
You've got list of dates above Appendix B.
No, Appendix A, Malad. Sorry, Malad. There's a separate list because that Appendix B, those were only related to bias.
Oh, this.
Your Lordship just has clause 48.
Yes.
Your Lordship has it? Yes. Small Roman 11, explosive detonators will be issued to the contractor from the corporation magazine only after the corporation has constructed the magazine. Corporation will construct the explosive magazine with adequate capacity at project site and will be the responsibility of the contractor to own portable magazines to keep explosive material for their day-to-day consumptions. The contractor shall also make requisite number of explosive vans to carry explosive materials to their various working fronts. Sufficient number of licensed professional blasters should be deployed by the contractor for safe handling of explosives from the time of receipt till the consumption in totality. The contractor will comply with all the relevant provisions of law, such as the Indian Explosive Act 1940, read with amendments thereto. Now, this license we pointed out in our submissions was not obtained by him. But be that as it may, thereafter, my lords, the same supplementary agreement which your lordships have already seen, saying, however, if any item of material as mentioned above cannot be provided by the corporation at any time, it cannot be claimed as a cause of delay by the contractor, and compensation or extra benefit whatsoever except granting of time extension will be entertained by the corporation. So, my lords, read as a whole, I would submit, my
How
lord,
does 4811?
only to the extent that your lordships have seen my submissions at page 70. One is on the factual aspect, that you had adequate stock of explosives. The second is that you did not even have an explosive license at the relevant point of time, which you...
How were they required to have an explosive license?
Because, my lords, your lordship, the last three lines, my lords, contractor shall
comply with the relevant provisions.
Yes, and
but you were supplying the explosives.
We were supplying the explosives to them.
So now, you required to have the license.
We required to have a license, my lords. My understanding, my instructions are that even they were required to have a license for the purposes of use and storage.
Part of your
very well. I leave
argument.
it. I leave it.
Part of your contention.
Very well. I leave it.
Yes.
So my submission is, my lords, twofold. One is that it is non-reason. There are no reasons have been stated.
And the other is bar.
And the other is bar. Your lordships have noticed, my lords, that the tribunal itself records that the following submissions have been made, but doesn't deal with them at all. Then, my lords, I come to the next point with regard to short supply of cement and steel. I'll just give your lordship the relevant page numbers of the award. The appellant's contentions are at pages 70 and 71. The findings returned, my lords, are from page 97 to 99. Now, the express bar is the same thing that your lordship have already seen for explosives. It's the same clause. Because in the list of items that are delineated, cement and steel is one of them.
So page 7 of Appendix C.
That's correct, my lord. I've also got the full supplementary agreement here. I just wanted to verify myself. Your lordship will take it that cement and steel is also there. So therefore, the submission, my lords, is the same as the submission in the context of explosives. So that's my first submission. We'll hand it over later when you get a slightly better copy. Because it's slightly dim copy. The second submission is, my lords, again, if your lordship sees the reasoning, we've specifically pleaded with reference to the correspondence that the delay was actually on their part and there was actually underutilization of both cement and steel. Now that again is recorded but not dealt with. If your lordship goes to the award from page 97 to 99. Please see, my lords, under D, delay, delay due to non-issue, short issue of cement and steel as per requirement of works as projected in the said program. The AT has gone through the submissions of claimant and respondent in this regard. The tribunal finds that there has been substantial delay in supply of material of construction, that is steel and cement, from the respondent side, causing delay in carrying out works by the claimant. 3 issues: delay due to non-availability of Princess Access Road being constructed, maintained by the respondent, delay in issue of construction drawing, and non-supply or short supply of explosive via cascading effect in the progress of construction, that is planned use of cement not being possible. The consumption of cement against availability will get affected, due to which work could not be executed as per the agreed construction program due to several reasons of delay attributable to the respondent. The AT notes that the respondent's defense, further, there is no absolute liability under the contract agreement to issue construction material, and the same are issued subject to availability and cannot be construed as cause of delay or a ground for claiming compensation. As contended by the respondent, the provisions in the contract that non-issue of material by the corporation at any time cannot be claimed as cause of delay by the contractor, and compensation for extra benefit whatsoever, except granting of time extension, is not applicable to the present case, as no extension has been granted, but only provisional extension has been granted up to 30/6/2004, a status which continued up to 9/6/2004, when the works were suspended by the respondent. Further, the claimant applied for extension of time up to 30/4/2005 under its letter dated 15/11/2003. The respondent granted provisional extension of time up to 30/6/2004 under its letter dated 29/12/2003. The tribunal notes that the respondent has relied on the provisions of Section 55 of the Indian Contract Act and the decision of the Bombay High Court in the matter of Hindustan Petroleum Corporation Limited, Mumbai versus Bartley Boy, Environmental Engineers, 2008 to RAJ 584, Bombay High Court, paragraphs 12, 13, 14, 15 and 17, stating that if the contractor has accepted the extension of time beyond the stipulated period of completion and has also failed to issue notice under Section 55 of the Contract Act, he will be claiming compensation and the damage for such delay. The contractor is not entitled to claim any compensation or damages for any loss occasioned due to the delay of any nature on the part of the respondent. The AT opines that this judgment is of no assistance to the respondent, since it is factually different than those in the present arbitration. Inasmuch as the legal citation, the delay as pointed out by the contractor in that case was due to force majeure, and in the present case the delay is due to the respondent corporation. Secondly, provisional extension has been granted by the respondent up to 36/2004, and there is nothing produced on record to show that the final extension was at all granted. On 15/6/2005, the claimant, under the letter number such and such submitted, claims for compensation and for additional expenses or losses occurred during the stipulated contract period on account of various deviations, non-compliance of conditions and stipulation of contract agreement on the part of the respondent. The claim was submitted to the head of project, who is not engineer in charge of the work in question, for the purpose of entertaining the claims. However, it is also noted by the tribunal that by letter dated such and such, the respondent certified all major civil works of Turial Hydroelectric Project Mizoram has been suspended indefinitely since 9/6/2004. This position translates into a situation where the contract works are retrospectively suspended indefinitely on 26/4/2005 with effect from a date that is 9/6/2004, that is prior to 30/6/2005. which is the provisionally extended time limit date. Therefore, the tribunal holds that the claimant is entitled to compensation on account of delay in non-supply or shortage relating to less consumption of construction material by the respondent. Now, my respectful submission is twofold. Firstly, the express bar as argument is specifically raised, not dealt with. That's the first point. The second point is, Mullets, if your Lordship just sees paragraph 2, where the finding that there has been a substantial delay is based purely on ipsi dixi, Mullets. There is no reasoning, there is nothing, Mullets, but to find as to how the arbitrator, the learned tribunal, reaches this finding. Because I have specifically contended at page 70, if your Lordship sees, if your Lordship sees page 70, number 6, as regards the issue of non-supply or short supply of cement and steel, the respondent averred as follows. The respondent denied the allegation of the claimant with regard to non-supply of cement and steel being the cause of delay, and also denied the averments and submissions raised by the claimant in its letters dated 16/4/2003, 21/4/2003 and 7/5/2003. The respondent pointed out that as per the contract, the respondent was required to issue material to the claimant subject to availability at the project store. The respondent also pointed out that the contract clearly provided that if any item of material cannot be provided by the respondent in any time, the same cannot be claimed as cause of delay. The respondent pointed out that the records show that the required quantity of issue materials were issued to the claimant from time to time commensurate with the program furnished by the claimant, but the quantity of material lifted by the claimant was less than the demand placed by the claimant. Further, the respondent stated that in spite of repeated requests, the claimant failed to construct cement godown of adequate capacity till March 2003, which would have helped in working smoothly without interruption. The respondent cited its letter dated 1/3/2002, 28/1/2003, 31/3/2003, and 14/5/2003 in support of the contentions of underutilization of cement by the respondent. Now, nothing is dealt with in the award. These correspondences are not dealt with, and nothing is said at all. There's not even a word apart from saying that I find that there is substantial delay. Your Lordship has already seen page 97. So therefore, my lords, even this part of the award, in my respectful submission, falls within the broad fulcrum of A, express bar. Secondly, it being perverse and non-reasoned for not having dealt with, even in one line, the submissions made by the corporation. Yeah, tunnel collapse. Now, the next point, my lords, is with regard to, my lords, the purported delays. Tunnel collapse, my lords, the contentions in the award, my lords, are at page 73, and the findings are from page 100 to 101. May I, my lords, invite your lordship's kind attention to the findings first, my lord. I'll just, my lords, just a brief explanation as to what their case is on tunnel collapse, my lords. Well, if I may just explain what broadly the claim in the context of tunnel collapse is, my lords.
Yes.
There were certain, my lords, steel structures which were used by the corporation in order to, my lords, preempt any collapse of the tunnel. And there was a particular design which was provided. It is their contention that that design was faulty, which resulted in collapses in the tunnel, which again delayed the work. So therefore, it is for that delay that they are making a claim. Now, in respect of tunnel collapse, the tribunal records at page 100 that they did not argue anything on this aspect at all. Your Lordship has page 100, paragraph F, the head, delay due to hold-ups due to collapse of tunnel support on different occasions. The arbitral tribunal has gone through the submissions of both the claimant and the respondent in this regard. In view of the averments made by both the parties, the tribunal's findings are as follows. The respondent's averments of that the claimant has neither pressed the said ground nor made any submission on the aforesaid ground, and hence the claimant is deemed to have abandoned the said ground of delay is not correct, as the claimant in the SOC has claimed for the delays and the same has not been specifically withdrawn. The 80 notes that as per the contract, issuing of construction drawings was the responsible of the respondent. The claimant has carried out the execution of works as per approved construction drawings. The 80 notes that the claimant's assertion that the tunneling was also held up due to collapse of steel rib supports due to faulty design, as evidence from the fact that design of steel rib support was modified in effect to such collapse of support, although the same has been denied by the respondent. Further, the 80 notes that repeated collapse of ribs was also redesigned by the respondent. Therefore, denying of responsibility that ribs collapse was due to the design fault by the respondent cannot be accepted. The 80 notes the respondent's statements that answers of the witness Shri Garg to question number 193 and 195 of cross-examination are contrary to admitted records. However, the respondent did not produce any record to support its contention of the said admitted facts, and therefore the answers must be looked into in favor of the claimant. The tribunal's attention is also drawn to the stipulation of the contract document Lot 1 Diversion Tunnels Information for Bidders, Volume 3, Introduction, Paragraph 1.3, History of the Turial Project. It states that Northern Eastern Electric Power Corporation was entrusted by the Government of India in 1998 with the implementation of Turial Hydroelectric Project. Since then, NEEPCO has continued studies of the project and has obtained necessary statutory clearance from the various regulatory authorities. In addition, on pre-construction investigation work of the site are continuing and are at an advanced stage of completion. There is also specific provision and information of bidders under paragraph 6, geology subparagraph 6.6 diversion tunnels, wherein precautionary measures are required to be taken during tunneling. Particular care must be paid to the possibility of the occurrence of explosive gases such as methane. As this is not unusual in this territory, formations where lignite may occur, adequate precautionary measures are required. The tribunal finds that in view of these stipulations in the contract, the claimant cannot be faulted for design deficiency on the part of the respondent, resulting into collapse of steel ridge supports and delays due to such collapses. The responsibility of design was that of the respondent, and therefore the claimant is not responsible for design deficiency of the respondent. In view of the above findings, the tribunal decides that the claimant is entitled for compensation for delays attributable to the respondent. Now, firstly, my lords, this claim is not pressed. Secondly, if your lordships have already seen, it was for him, my lords, to have shown that the design was deficient. Now there is not even an iota of evidence led by him. In fact, the tribunal's finding is that the witness, that is Mr. Garg, who is their witness, does not really support their claim. So, and I have, my lords, in great detail also pleaded with regard to the tunnel collapse at page 73. Where we have said that this is on account of your fault, that there was a tunnel collapse. Now, at least, my lords, there should have been a finding to show that the design was deficient. And the tribunal could not have cased the onus on me. Originally, the onus was on them to show some design deficiency. So I respectfully submit, my lords, that insofar as this part of the award is concerned, it falls within my lords, three parameters. One, my lords, it's contrary to the principles of natural justice for the reason that a claim not pressed by them is also considered, in the sense that nothing was argued. So what can I respond to if they don't argue or press that particular claim? They may not have abandoned it specifically in letter, but they didn't make any argument. Second, even on merits, my lords, the finding that there was any design deficiency suffers from material irregularity for the simple reason that it was for them to show the factum of design deficiency, which they have not been able to show. And the onus has been wrongly cased upon me.
Come to bottom of page 100.
I am obliged to you.
Further 80 notes, last 4 lines.
Yes.
That repeated collapse of the ribs was also redesigned by the respondent, therefore denying of responsibility that ribs collapse was due to design fault by cannot be accepted.
Yeah. Now this is one fine. Now, my lords, you may improve a design from time to time, but that doesn't necessarily mean that the old design was faulty. But at least some finding should have been returned.
Fact, proof of the pudding is in the eating, that it collapsed.
That's a possible view. But my lords, that's a possible view.
You
but
know,
yes.
It's like reciprocator.
But it's not necessarily.
It could be. Same. It collapsed. The fact that it collapsed is your responsibility to explain how it collapsed.
Yeah.
So the counterpoint.
It's purely reciprocator.
So my response to this, my lords, is only this, my lords, very briefly. This particular claim was not even argued by them. So there was nothing for me to actually respond. That even the arbitral tribunal notes, my lords, that they didn't make any argument on this. Second, on design deficiency, because this was a tribunal, my lords, with persons, my lord, who had some specialized knowledge in the field. At least a line or 2 lines saying your original design was deficient. we've specifically argued, and those contentions are recorded, there is no deficiency. Thirdly, under the contractual provision, it was our case that it was for you to take certain precautions, and the tunnel collapsed on account of those precautions not having been taken by you. That's at page 101. That's also not dealt with. Page 101, if your lordship sees, second bullet point.
All contentions recorded but not dealt with. The last in particular.
The last part, my lords, of the paragraph at page 101. During tunneling, particular care must be paid to the possibility of the occurrence of explosive gases such as methane. Is not unusual in this territory. Formations which may where lignite may occur, adequate precautionary measures are required. So that's my respectful submission on this aspect. Then, my lords, I move on to the next point. With regard to, my lords, rock strata and deviation of rock strata in the tunnel during tunneling.
Yes.
I may just very briefly explain, my lords, as to what is their case. According to them, when the BOQ, when the original contract, the tender documents were furnished, there was a rough estimation in the tender documents as to what would be broadly the nature of the rock. And that rough estimation was formulated on the basis of whatever you could extract on the surface. But once you start tunneling, it's actually impossible to know as to what will be the status of the rock inside. So even if you do your best, you can't really get through with that. So there are contract clauses to that particular effect. Their case is that when we started the tunneling, we found that the nature of the rock was different from the nature of the rock which was originally disclosed. So it took much longer for us to complete the tunneling process. As a result of which there was delay, you need to compensate us for the delay. It is my respectful submission, my lords, that so far as even this particular claim is concerned, it's partly covered by an express bar. And secondly, on a meaningful interpretation of the contract provisions, it is very, very clearly indicated that the contract is on an as-is basis.
On
an as-is basis.
Yes.
And they had to inspect the entire site for the purposes of acquainting themselves as to what the geological condition was before bidding for the contract. So the question of paying them any amount more on account of some change in the geological outbreak, as is noticed by them, does not arise, and that is covered by the contractual. So partly it is on express bar, partly it is on interpretation of certain contractual.
No reasonable data was taken because clauses are actually.
Yes. Now, I may just give your lordship the page numbers first. The contention with regard to this head, page 72 and 73, and the findings are at page 103 and 104. Now, for the express bar, my lords,
Contention is at 10?
The contentions are at 72, 73.
72 to 73?
72 to 73.
Yes, findings.
And findings are at pages 103 and 104.
Yes.
Now, first, my lords, if I may come to the question relating to the express bar, if your lordship just sees page 2 of Appendix C. (3.10.1). A measurement for payment and payment for underground excavation will be made according to the relevant classification system specified above, separate quantities and unit rates for the previous excavation classes in different portions of the works are provided in the bill of quantities. The definition of excavation class given in the schedule are not to be considered as an accurate indication of the quantity of work, since the predicted and actual length of each excavation class may differ due to geological conditions encountered in the course of the work. The contractor shall not be entitled to any extra payment over and above the unit rates entered in the bill of quantities by reason of changes to the actual quantities of the various excavation classes. But I emphasize, though this is not emphasized in the appendix, on the expression the actual length of such excavation class.
Where?
Malodza, about 6 lines from the bottom. Since the predicted
Definitions of excavation class given in the schedule are not to be considered as an accurate indication of the quantity of work, since the predicted and actual length of such excavation may differ due to the geographical conditions, since the
due to geotechnical conditions encountered in the course of work. So it's very specifically contemplates the amount of time taken, and then the bar is enacted in the last 4 lines. They say you will not be entitled to anything extra over and above the unit rates entered in the bill of quantities on account of any changes to the actual quantities of the various excavation classes.
Yes.
So in my respectful submission, Maloj, so far as this clause is concerned, it does prescribe an express bar. Now, having said that, Maloj, there are 2 other clauses which are of some importance, Maloj. Clause 6.6 and clause 7. Your Lordship just goes to Appendix A, page 56. Clause 6.6. Diversion tunnels. According to a geological map, your Lordship has that one. I'm so sorry. Lordship, please. 6.6, diversion tunnels. Book 2, information for bidders. According to a geological map and cross-section prepared by GSI, along the tunnel alignment, the following types of rocks were differentiated. Sandstone, fine-grained and often silty sandstone, approximately 36% of the total tunnel length. Massive siltstone, almost without visible bedding, approximately 34% of the total tunnel length. Siltstone laminated and with alterations of silty shale and rare beds of very hard sandstone, approximately 8% of the total tunnel length. Shallow sandstone, fine sandstone, with alternating shale lamina, approximately 7% of the total tunnel length. Shady shale claystone, alternating with thin sandstone layers, approximately 15% of the total tunnel length. As observable in drill holes BH18, BH13, BH14, shales and partly claystone show distinct slacking properties, that is a deterioration and breakdown after exposure by drilling and excavation. It may begin almost immediately with visible cracking and often noticeable heaving. At the present stage of knowledge of the geological conditions along the divergent tunnel alignments, the following percentage distribution of rock classes can be roughly estimated. Very poor rock 30%, poor rock 34%, fair to good rock 36%. This estimate is based on field mapping carried out by GSI, geologists, on the evaluation on drill hole data, the fact that the existing drift needed to be completely timber, supported due to weak rock conditions and frequent shear zones, and experience gained in tunnels excavated in similar weak rock conditions. The frequent shear zones observable, both in drill cores and the said investigatory drift, are caused by extensive faulting mentioned in 6.1. So my submission is, Malods, that at that stage itself, it was laid bare to them that this is only a rough estimate. Now their case is that ultimately when we started drilling, what we found was not in parity with what has been estimated here. But we had made it clear to them that it was only a rough estimate. Second, my lords, if your lordship sees, clause 7, which your lordship will get at page 60 of the same appendix. The bidders in their own interest. Your lordship has that? The bidders in their own interest are also advised to inspect and examine the site.
Page?
And it's, sorry, Manoj.
70 of?
Page 60, Manoj, sorry.
Oh. Yeah.
The bidders in their own interests are also advised to inspect and examine the site and its surroundings and satisfy themselves before submitting their bids in respect of the site condition, including but not restricting to the following, which may influence or affect the work or cost thereof under the contract. Come to B, Manoj. Geological, meteorological, topographical, and other general features of the site and its surroundings, as are pertaining to and needed for the performance of the work. Then please come to D. All other information as to the risk contingencies and other circumstances which may influence or affect the work or cost thereof under this contract. And E. The bidders should note that information, if any, in regard to the site and local conditions, as contained in these bid documents, has been given merely to assist the bidders and is not warranted to be complete. 2. The bidders should note and bear in mind that the corporation shall bear no responsibility for the lack of acquaintance of the site and other conditions or any other information relating thereto on their part. The consequences of lack of any knowledge as aforesaid on part of the bidder shall be at their risk and cost, and no charges or claims whatsoever consequent upon the lack of information, knowledge or understanding shall be entertained or payable. Your lordship notes the word payable, Manoj. Shall be entertained or payable by the corporation. So my respectful submission is that so far as these aspects are concerned, with regard to geological conditions and the deviation in rock strata, the clauses of the contract, which I just placed before your lordships, also expressly factor the change in geology and mandate that nothing further will be paid to you in case of the geological condition, the geological outbreak not being in conformity with what was disclosed in the pre-bid documents. Now, my lords, if I may just take your lordship through to the learned arbitrator's findings at page 103 and 104 in this regard. But the finding, insofar as rock strata is concerned,
H.
yes, 103 Malats. The AT has gone through the submissions of both the claimant and the respondent in this regard. The AC finds that the claimant's averment regarding the respondent being the authors of the contract and that the respondent was continuing studies which were at an advanced stage of completion as relevant and acceptable. The claimant has also stated that the respondent has carried out detailed investigations from the government agencies, and this data was incorporated in the invitation to bids, which was the basis of quoting and planning for the works. The AT notes that the claimant's reliance on the judgment of the Honorable Supreme Court in the matter of Tarapur and Company versus Cochin Shipyard and others in this regard. The AT also notes the claimant's contention that the construction program submitted by the claimant, both at inception and later, were accepted by the respondent without any reservations whatsoever. The AT does not find the argument of the respondent that the present stage of knowledge of the geological conditions, along with diversion alignment, as provided in clause 6.6 volume 3 information of bidders, was roughly estimated as per geological information provided by the geologist. The claimant with his vast experience was required to make his own assessment as acceptable. This is especially so when the construction program was accepted without any reservation. The AT notes that the respondent made the information of bidders as part of the contract. In such a case, the respondent cannot now turn around and say that the claimant was in a better position to estimate the geological parameters based on its vast experience. Ratio in the matter of Tarapur and Company versus Cochin Shipyard fully supports the contention of the claimant. Accordingly, the arbitral tribunal decides the delay was due to deviation in rock strata in tunnels, which occurred as compared to that provided for in the contract and hence attributable to the respondent. Now, with the greatest respect, my lords, even this reasoning, in my respectful submission, begs the question. When I lay bare, as per my contract provisions, that I am only giving you a rough estimate, the obligation is on you to inspect, make whatever due diligence that you want, and then come to a particular finding on the question of rock strata. Those clauses, reasonably interpreted, can only lead to one conclusion, that is to say that you can't be paid anything extra. If tomorrow the geological outbreak shows that it is not the same as what was stated in the BOQ. That aspect, my lords, has not been considered at all by the tribunal. So in my respectful submission, my lords, this would come within the category of express bar. Your lordships have also seen in 6.6 it says, no amount will be payable, which I had emphasized upon. As well as, my lords, the contention that it doesn't even deal with, the tribunal doesn't deal with even the contention specifically urged by us, my lords, at page 72, my lords.
17 of your written submission, because clause 7 is not mentioned.
Yes. And 17 also of our written submissions which we had given to the tribunal. Should I show that part, my lords? Very well. So in my respectful submission, there is absolutely no reasoning of the tribunal, makes the award non-reason, and would also therefore fall within the broad fulcrum of patent illegality.
Yes.
Yeah. Then I come to the next aspect, my lords. May I continue? Would your lordship be rising for lunch or?
Purpose one?
Lordship, please. Yeah, because the other 2 or 3 points are a little involved, so therefore may take a little longer. So
this you're getting now into.
I'm getting into, my lords, extraction of boulders.
You're getting into extraction of boulders. So you want to do it post lunch.
I can do it post lunch or
2 o'clock.
2 o'clock.
2 o'clock.
No. It's all right, but if the lordships want to continue post.
What is it?
No, my lords. I'll do it at 2 o'clock.
I may be, my lord, in some difficulty in the afternoon, my lord. I mean, I don't want to stop my learned friend, certainly, my lord.
He can continue.
Yes.
He can continue. And you'll reply immediately after that.
Lord, I may not be able to reply tomorrow, but...
No. We don't allow piecemeal kind of thing.
My lord, because
Start to finish, we're indicated. Start to finish, start to finish. We're indicated very clearly.
my lord,
Make some other
may I make one request? My lord?
Yes.
Would your lordships then have it day after tomorrow?
No. Start to finish.
Then, my lord,
Absolutely clear.
may I make one suggestion, my lords? There's a little bit that I need to tie up in terms of my preparation on this. Can I continue tomorrow in the pre-lunch session? And then my learned friend can reply thereafter. Instead of post-lunch, if I can continue tomorrow.
He's saying tomorrow he won't be able to.
Okay. No, so tomorrow I will definitely finish tomorrow. my lords. And my learned friend can
I can do it
respond.
day after.
Right.
I'm so deeply grateful.
So we'll give you the pre-lunch tomorrow
Lordship.
and for him day after.
Lordship, please.
So today post cannot. But you're going to go back and come.
Lord, I'll have to do it by VC, my lord. I won't be able to do it. Come back.
Okay.
I'll do it by VC.
Yes, we'll call it on. Wait, Mr. Bose, we'll call it on. Yes, call on the next one, please.
So deeply grateful.
I'm grateful.
Item number 7.
The direction by your lordships to file an affidavit,
Yes,
and they were supposed to file a reply.
yes,
My lord, so lordship kindly sees your lordship's last order,
yes.
my lord, of May 2023. My lord, the purpose of the affidavit was that, my lord, the last portion of the order says that the names of the present partners would be given immediately. My lord, kindly see the last portion of the order.
Yes, where is Dr. Modika?
Yes, my lord, I tell your lordship what has happened.
Yes.
The time to reply was expiring on 9th. Up
Yes.
till 9th May, we did not get the names of any of the partners. What happened on 10th evening via WhatsApp? my
Just
lord, it
send
was
for
only-
Dr. Modika, Mr. Pal.
My lords.
Yes, my lord, what happened? My lord, on the last, on 10th, that is after the time expired, a WhatsApp message was given by Dr. Mozika, although it should have been given by
My
the
learned friend, Mr. Mozika's
Please,
colleague is here.
Lordship, I appear
Yeah, I'll
on
tell you-
the senior counsel.
I'll just tell you, Lordship, what has happened.
You write a
My lord,
letter, we'll give you time till today, you file your affidavit thereafter.
Well, I'll tell you, Lordship, what has happened. We came to know through a WhatsApp message
No.
the names of.
He is giving a letter to your advocate and record over here today.
Yes.
And thereafter you take the steps that were necessary to be taken in terms of the previous order.
Well, it's
Yes, only one thing, my lord. We now know by WhatsApp message as to who are the partners. Now, my lord, I can tell your lordship, just I need clarification with regard to the names of the 4 partners. My lord, 3 of the I have made my investigation through Google. My lord, I have done in Street that they own distilleries and they own, my lord, bonded warehouses. The 3 partners. All I want, my lord, these 3 partners were also present at the meeting which held on 22nd December, my lord, of 2023. All I want, my lord, the names of whether any of the 3 partners have any interest in any distillery or any bonded warehouse.
Mr. Bose, if you want information, write to them. If they don't give you that information, then apply to us. Then we'll consider whether that is necessary. We can't just ask them to inform them of their, the cut of their suit or the size of their feet.
No, I have.
You write to them. If this information is relevant in the context and if they don't furnish it to you, then we'll consider relevancy and then give directions.
Let's, if I may,
I
entire thing can be sorted out, Milits. The private respondent is a party here, Milits. It's a partnership firm. If the partnership deed is filed before your lordship, Milits, it will clarify all these issues that they have not filed.
No, he's wanting something more.
Milits, all the queries by the learned senior counsel, Milits, would be covered in that. The names of the partners, their shareholding in the company.
You are appearing for whom?
On behalf of the senior counsel, Mr. Muzika.
He is appearing for which party?
Lordship, for the
Private
private respondent.
Private respondent.
Private respondent.
That is the super
Private
bond.
respondent number 8.
3, my lord.
Number three.
Completely-
Number three.
Three minutes.
Number 3.
Bonded
Very well. It is submitted on behalf of the petitioner that the information required to be furnished in terms of the previous order of May 2, 2023 pertaining to the partners of the firm was sought to be indicated by a WhatsApp message, full stop. Some further information is sought, paragraph. The partnership deed pertaining to the partnership firm, respondent number 3, should be filed in court in course of this week, full stop. The writ petitioner will be entitled to inspect such partnership deed in the presence of an officer of this court, full stop. The petitioner may then file a supplementary affidavit within a week thereafter, and
My lord, may I say something, my lord? Subject
replies to such supplementary affidavit be filed within a week thereupon. Yes, Mr. Bose.
Yes, my lord, the order said that the names were to be indicated by letter addressed by the advocate on record. My lord, so officially nothing was communicated by them. So, my lord, WhatsApp, whether your lordship, it's an informal WhatsApp by Dr. Muzika. My lord, whether your lordship will...
No, we are not accepting that. What we are asking him is to file the partnership deed and for you to inspect the partnership deed. That's the end of the matter. They will file the partnership deed and you look at it, the names from the partnership deed.
Yes, very well, my lord. And the additional I will ask by a letter. I will annex
Yes.
it in my supplement.
Whatever other information you need. Yes, Mr. Khanna.
Supplementary
My lord,
Supplementary affidavit?
filed by the petitioner's lordship on 15. We also require 2 weeks time, lordship, to file it.
Very well. We've given them time to file that supplementary affidavit after a week from whenever they file this. That you do in course of this week. Your partnership deed. Have you followed?
Lordship.
You give it to the court officer, it will be kept with the records,
Gotcha.
and Mr. Pal's advocate on record can inspect it and then get whatever information from there.
Lordship.
Only a copy, not the original.
Only a copy, Lordship.
Only a copy, not the original.
Lordship.
Yes, anything else, Mr. Bose?
yes, my lord, your lordship is fixing this matter or fixing the particular date. My lord, may I, my lord, after this...
It'll go on 3 weeks from now, because that's the time that we've given.
May please, your Lordship. Lordship, I have a humble submission. Lordship, if this matter may be fixed on 20th of June, Mr. Banerjee will be addressing your Lordship.
No, we cannot fix that way. Whatever date is, 3 weeks afterwards, give that date.
Hello,
Yes. That will be close to that time, but not exactly that time. Yes.
Obliged.
These papers, just send to my chamber, please.
Lordship, same order for 8, 7 and 8.
7 and 8 are connected matters.
Common order. It's always been a common order, has it not?
Lordship.
It's been a common order.
Don't mix up the papers, please. Those separate and these separate. Tie these up separately.